Good evening. We are so proud to stand before you and to tell you that when we announced the charges 15 months ago, we also promised that we would seek the truth for Trayvon Martin and due process for George Zimmerman, that we would give all of the facts and details of this very difficult case before a jury, and that we chose to do it that way because we felt that everyone had a right to know everything about this case. That for a case like this to come out in bits and pieces served no good to no one. As Mr. Guy told the jury yesterday, to the living we owe respect, to the dead we owe the truth. We have been respectful to the living. We have done our best to assure due process to all involved, and we believe that we brought out the truth on behalf of Trayvon Martin. There are so many people to thank, starting with Sheriff Esslinger and his entire sheriff's office. They've been so good to us, as has Michelle Kennedy and all of the people here. As you know, we traveled from our own circuit to be here, and that has not been easy, but it's been made so much the better by having so many people be gracious. You have respected our privacy, you the media, because we said after the press conference that we were going to try this case in the courtroom, not in the media. And we appreciate you respecting our privacy and doing that. I have an amazing team of lawyers, paralegals, and investigators who put their lives on hold and with me accepted the governor's assignment to take on this difficult investigation and this difficult case. And I'm so proud to stand here with them and to be part of the historical aspect of this case to show that the American justice system can and should only be done in a court of law. I don't believe it helps anyone for us to be out espousing opinions about our cases. And I think, as you see, we put this case in front of a jury, and that leads me to thanking the jury for the 16 hours of deliberation that they took to go over all of the facts and circumstances. What we always believed was that this was a case of details that had to be analyzed very, very carefully. I never could quite understand people, even people with law degrees, who had not read all of the police reports, who had not read all of the witness statements, yet who came up with opinions one way or the other. And this team of people standing with me, who stand with me every day in the Fourth Circuit and try tough cases like this all the time, knew that we had to do the best to get the entire facts and details of this case out and before a jury. I think this jury worked very hard. We honor them for their service. Judge Nelson worked very hard. We want her to know that we appreciate all that she did to keep this case on course. And of course, our hearts, as always, go out to our victims' family and to all victims of crime. But as long as they know that there will always be prosecutors fighting for the truth, I think that victims will continue to rely on this justice system. I'll turn it over. Bernie, would you like to say a few words?
I want to thank you all for respecting our privacy. I am disappointed, as we are with the verdict, but we accept it. We live in a great country that has a great criminal justice system. It is not perfect, but it's the best in the world, and we respect the jury's verdict.
I'd also like to thank you for your time and attention that you give in this case. Both sides are deserving your attention. We have, from the beginning, just prayed for the truth to come out and for peace to be the result, and that continues to be our prayers, and we believe they have been answered.
I'd just like to say to the family of the dead teenager Trayvon Martin that I appreciate the way they have handled this matter. They've been dignified, they've showed class, they have kept their pain in check when they needed to, and they have grieved when they needed to. And I think that they have handled it like ladies and gentlemen. It can't have been easy, it won't be easy, so I ask that, I know y'all have a job to do, but when you approach all that, keep them in mind too. Thank you.
I also want to thank the thousands of people who sent prayers our way, held us in their thoughts throughout this entire process. We got a lot of encouragement from a lot of people. But again, this is something that we do in our circuit. We try a lot of murder cases. We never know what a jury is going to do. We go into every case putting our best case forward and leaving it in their hands, and that's what we did in this case. Is it appropriate to take questions?
Why did you overcharge?
Well, we charge what we believe we can prove based on our Florida standard jury instructions and based on the facts of the case. So that's why we charged second-degree murder. We truly believe that the mindset of George Zimmerman and the words that he used and the reason that he was out doing what he was doing fit the bill for second-degree murder. Second-degree murder is a general intent crime, unlike first-degree murder, which requires specific intent and sort of a design.
Well, the jury obviously didn't agree.
I'm sorry, I wasn't finished with my answer.
The jury obviously didn't.
I didn't finish my answer. And so because it's a general intent crime, you look at the way the crime is committed. It doesn't have to be between two people who know each other.
Ms. Corey, what was the greatest challenge you feel that your team faced in winning the verdict that could have been to your side?
Well, I think that one of the greatest challenges we faced is taking over a case that had already been being investigated for as long as it was before we stepped in and were able to start conducting our own investigation. It was a challenge, but it's one we took when the governor assigned this case to us, and we did everything we possibly could. Yes, ma'am. Oh, I'm sorry. Would you just let me know, and I'll answer the reason. Thank you. Yes, ma'am.
For the Times of London and the Daily Beast. I just wondered if you're able to pinpoint one aspect of the case or one item of evidence or witness evidence that let you down on this.
Oh, well, we never would say that anything let us down. We are used to the imperfection of both witnesses and evidence in criminal cases. And we've all been trying criminal cases for a very long time. And you just can't guess before you take a case to a jury how something's going to turn out. So you work very hard, you put your witnesses on the stand, you argue your case to the jury, and then you focus on the law and the arguments, and then you leave it in the hands of the jury. What we promised to do was to get this case in front of the jury and give George Zimmerman and Trayvon Martin each a day in court.
When you couldn't say how the fight started, why did you...
I'm sorry.
Oh,
Sorry. Lisa Lampkin, NBC News.
Yes.
Can you tell me if you and the prosecution team have had a chance to speak with face-to-face Trayvon Martin's parents?
Well, I spoke with Sabrina earlier today. Do you mean since the verdict?
Yes, ma'am.
No, we have not. We actually came straight down here after the verdict.
Dana Siobhan, WFTV. I was
Yes.
wondering, do you think that the judge got it wrong with the felony murder based on child abuse, or were you just disappointed with that ruling?
Oh, thank you for asking about the lesser included. Schedule 2 lesser included are part of the standard jury instructions. Once you've tried your case, then you are to look at, obviously, second-degree murder. Manslaughter is a necessarily lesser included. It's a Schedule 1. And then if we believe the facts of our case fit any of the Schedule 2 lesser included, then we ask for them. A charge conference is usually a very basic part of the trial and doesn't require a lot of drama, quite frankly. So because Trayvon Martin was 17 at the time he was killed, we believe, because we believe it was an intentional killing, that the facts fit the third-degree felony murder. Third-degree felony murder is a non-enumerated felony. It's a complicated concept, but it is a Schedule 2 lesser included, which is why we requested it. We request our lesser included. The judge gives what she believes is appropriate, and that's how we try cases. Oh, I'm sorry.
David Elias from the
Hi,
Miami
David.
Herald. Can you talk about Florida Standard Ground Law and whether that the changes in the law in 2005 affected the facts in this case and whether this case could have been won, perhaps, pre the changes in the law?
Well, justifiable use of deadly force has changed to a certain extent. Stand your ground is a procedural mechanism, as we call it, where we fully expected, because of what we were